All right. Okay. More chairs are coming, but they can happen while I'm talking, just not while Michael's talking. So it is with enormous pride and pleasure that I welcome you all to this event, where we will formally mark the chairing of Professor Michael Klarman as the Kirkland and Ellis Professor of Law. We are thrilled to be joined today by members of Professor Klarman's family. His wife, Lisa Lansford, is here. Brother Seth Klarman is here. They're hiding in the back row because they're afraid that they'll be seen sleeping. I give my personal thanks to Seth that you and your wife, Beth Klarman, and your children helped assist our efforts to recruit Michael to come join the Harvard faculty, or to be near you, or was it to be near the Red Sox? I'm not sure. Either way, we all win. The chance to celebrate Michael and his stupendous scholarly accomplishment is enabled here by the magnificent generosity of Kirkland and Ellis. Kirkland and Ellis was the first law firm ever to give a chair here at Harvard. Kirkland itself is synonymous with excellence in its service to clients, in its recruitment of outstanding talent, in its commitment to diversity, and its engagement in community service. I'm from Chicago, but anyone from anywhere in the world knows that Kirkland is synonymous with excellence. We're lucky today to be joined by Scott Falk, a partner in the Chicago office and a leading expert in mergers and acquisitions, as well as securities offerings, and a graduate of Harvard College and Harvard Law School. We are so grateful to you, Scott, for your own efforts on behalf of Harvard Law School, including notably for the Kirkland and Ellis Hall, which is in this building, and if anyone hasn't seen it lately, you should go see it on your way out. We thank you for representing here the 150 or so HLS grads at the firm, whose individual pledges combined with the contributions from the firm's matching fund created this chair. Donald Kempf and Jack Levin spearheaded that effort, and when the chair was first launched, Donald said that, and I quote, "We recognize our responsibility to support schools upon which we depend for new lawyers. Thanks to the broad-based and ongoing support of the firm and its Harvard Law School graduates, we're able to present this gift, the largest in the firm's history. We're grateful to Harvard Law School for what it provides to its students and to the legal community. We decided to make a contribution that would benefit the school's important tradition of excellent faculty." And Jack told me that he hoped that this magnificent gift would inspire other firms to follow suit. And wonderfully, they have. The devotion and leadership of Kirkland's HLS grads has been extraordinary, and with the recent gift that we used to rename the Langdale South Classroom as Kirkland and Ellis Hall, as well as this chair, it is a wonderful relationship that we have with this firm. The first holder of the Kirkland and Ellis chair, our own David Wilkins, now sits in a chair that was specifically devoted to his field of professional ethics, and that allowed us to bestow this very special chair on the extraordinary Michael Klarman. To back up that adjective, extraordinary, what else could I do? I went to Google. And it turns out that someone named Michael Klarman won $18,325 in a no-limit Hold'em poker event in April 2008. But the audacious winnings of our Michael Klarman take a different direction. Michael Klarman's recent election to the American Academy of Arts and Sciences is simply one moment of recognition for this superb scholar of American constitutional history. Michael's work challenges the dominance of lawyers' frameworks, preoccupation, dare I say it, with legal doctrine, and brings meticulous but also sweeping attention to the underlying causes and effects of constitutional law. He enables extraordinary understanding of constitutional developments, including the psychological, the social, and the political contexts and effects. His landmark 2004 book, From Jim Crow to Civil Rights, the Supreme Court and the Struggle for Racial Equality, examines the contributions of the civil rights movement, the political power shifts of the Black Northern demographic changes, and competition for the hearts and minds of third world nations during the Cold War. The book bravely explores how the court's decision in Brown v. Board of Education may have been more detrimental than beneficial, because perhaps it galvanized white opposition to desegregation. This book received a lot of recognition, and it also received something known as the Bancroft Prize, which is one of the most prestigious awards in American history. In fact, in the past, it's only been awarded to one other legal historian, who happens to be our own Mort Horwitz. After he won the Bancroft Prize, Klarman tried to leverage the honor into more respect at home, but he said that he found that his wife and kids simply weren't that impressed. So I'm making a T-shirt for you, Michael, with the words from the reviewers of the book, who describe the book as, and I quote, magisterial, authoritative, definitive, exhaustive, ambitious, nuanced, and luminous. So that might help at home. Michael's other work includes the book Unfinished Business, Racial Equality in American History. This one secured the words lucid, riveting, tour de force. Maybe that's the back of the T-shirt. And it demonstrated how court decisions tend to reflect the racial mores of our times and the times in which the decisions are made. Despite the high profile of the Brown v. Board of Education case, the argument goes that the Supreme Court, through most of American history, has not been a heroic defender of the rights of racial minorities. It's a very sobering book. But it's not just his books, it's also his articles that are classic and critical. It's okay, you can make noise, that's only me talking, but when Michael talks, there's no noise. His articles include, and I hear just some titles, Bush versus Gore through the lens of constitutional history, Social Reform Litigation and Its Challenges, an essay in honor of Justice Ruth Bader Ginsburg, How Brown Changed Race Relations, the Backlash Thesis, Brown and Lawrence, and in parentheses, and Goodrich. Michael's occasional pieces appear in leading publications such as the New York Times, the Boston Globe, USA Today, and Time Magazine. And with the combination of his great learning, his mastery of detail simultaneously with his ability to focus on the big picture, Michael's work has generated enormous respect inside and outside the legal academy. His challenges to the confines of traditional legal preoccupation should not, however, lead us to doubt that he has affection for law and for lawyers. So, in fact, I did some research into his research into which sports teams to which he should attach his undying affections. He researched and he found the teams that were led by lawyers. So Theo Epstein, who says that the law degree helps when he negotiates contracts, and Larry Luciano. And also, I think that there might be a few others with some lawyers involved, but I think these are the ones that have won your heart. When the law school here voted Michael a post as professor, Michael said, "The fact that Harvard is just a long stroll from Fenway Park makes this almost a dream come true." Now, my spies tell me he's wondered whether he can rearrange his teaching schedule to be in Fort Myers for the Red Sox spring training. We can talk, but I'm glad that you used spring break to go instead of missing class. And in fact, it was his affection for the Red Sox, as well as Elena Kagan's powers of persuasion, that allowed us to convince Michael to come here from his prior distinguished career at the University of Virginia School of Law, where he was the James Monroe Distinguished Professor of Law and the Elizabeth D. and Richard A. Merrill Research Professor and Professor of History. He won there the first Roger and Madeline Traynor Faculty Achievement Award for Excellence in Legal Scholarship, and other awards include the University of Virginia Harrison Achievement Award, the State Council of Higher Education Faculty Award, and the All-University Teaching Award, which is one of the university's highest honors for excellence in teaching, research, and service. So I can't resist quoting what Dean Elena Kagan said when Mike joined the faculty. She said, "Having Mike Klarman join our faculty is like winning a trifecta. He's a path-breaking scholar whose work abounds with new insights into some of the most important moments in American constitutional history. He's an extraordinary teacher, as Harvard Law students discovered when he was a visiting professor here, and he is a renowned institutional citizen and colleague." Our colleague, Bill Stuntz, who taught at UVA with Michael, said, "In addition to being one of the world's greatest human beings, Mike has more integrity than anyone I know. Academics tend to go for what's clever. Mike aims for the truth, and he nearly always hits the mark. My admiration for him knows no bounds." Mike joined the faculty in 2008 and commuted for a year while his faculty relocated. I then prevailed upon him to be the cause of this first chair lecture event on my watch. And Michael will speak here today about racial equality in American history. We're thrilled to have the occasion to honor you and celebrate you.
Thank you. Thank you. I'm delighted to be with you here today to celebrate the beginning of another baseball season. Hope spring's eternal at this time of year, even for Cubs fans like the Dean. Anything's possible. I feel a little overwhelmed, certainly humbled by that extremely kind introduction. Thank you to Martha for that. It's quite undeserved. I want to say a couple other thank yous before I get started. My dear friend Bill Stuntz, who I think did not make it, told me today he didn't think he would be able to make it. He had doctor's appointments today. I wouldn't be here today without Bill. Bill is responsible, I think, in large part for my appointment to the Harvard Law School faculty. It's through his example that an entire generation of junior faculty at Harvard and Virginia aspired to accomplish things in their scholarship that they never otherwise would have dreamed was possible. So thank you to Bill. I also want to thank my brother, maybe embarrass him a little bit. He has supernatural powers. My brother Seth set a standard of excellence when we were young that I long ago gave up trying to match. Anyone growing up in Seth Klarman's shadow was bound to become the black sheep of the family. I long ago reconciled myself to that fact. If it were not for his constant inspiration and support, I never would have been anything but a poor old Baltimore Orioles fan, which is a really pathetic thing to be, especially these days. Thanks to my spouse, Lisa Landsverk, who's sitting next to Seth. Lisa makes everything I do possible and at the same time worthwhile. Thanks to all of you, my dear students and colleagues who make me feel so fortunate to be a Harvard Law School professor. So I am deeply honored to be the Kirkland and Ellis Professor of Law. As the dean was explaining, this is a very distinguished Chicago-based law firm. It was founded almost exactly 100 years ago. Indeed, it was founded the year after the Cubs last won the World Series. I'm very pleased that Scott could be here today to represent the firm in person. He's going to get a chance firsthand to see how much of a mistake they made to endow a chair that ultimately ended up in my hands. Kirkland & Ellis has had many eminent lawyers. Perhaps one of the most famous, who I believe is still of counsel, is former Solicitor General Ken Starr. Judge Starr, General Starr, was actually appointed to the D.C. Circuit the year I was clerking for then Judge Ruth Bader Ginsburg. He was 37 years old the year he was appointed. He looked like he was 27 years old, and we used to refer to him, though never to his face, as the boy judge. In any event, I'm very honored to have the name of this distinguished law firm affixed to my title. Chairs are actually funny things. One of the things that I was reluctant to give up about the University of Virginia Law School in Charlottesville, one of several things, was that I was the James Monroe Distinguished Professor, and I liked being the James Monroe Distinguished Professor. James Monroe, I think, is an underappreciated founder and an underappreciated president. He was a Revolutionary War hero. Interestingly, he was one of the leading opponents of the Constitution in Virginia. He was one of the leading anti-federalists. He helped negotiate the Louisiana Purchase in 1803. James Madison, Secretary of State. Then he served 2 terms as president. He was partly responsible for pushing through Congress the Missouri Compromise, which held the nation together for a couple of decades, notwithstanding the deep-thought disputes over slavery. Finally, he had the good sense to die on July 4th, just like Thomas Jefferson and John Adams had done 5 years earlier. Now, I liked being the James Monroe Distinguished Professor, but I admit I was always a little bit jealous of the James Madison Professor. Virginia also had one of those. Now, you have to admit that that would be any law professor's dream in the United States, to be the James Madison Professor of Law. Think about the stature that that would bring you in class when some student decided to disagree with your interpretation of the Federalist Papers. Would say, "Excuse me, I'm the James Madison Professor. I knew James Madison. You, buddy, are no James Madison." Well, Virginia had great professorships, but Virginia also, because of its unhappy racial history, had some real duds. I see my colleague George Trianis, who will, I think, recall some of the professorships at Virginia. One of the ones that I think we, as junior colleagues, were most relieved that we were not appointed to was the John Stennis Professorship. Now, most of you are too young, but my colleagues on the faculty will remember John Stennis. He was one of the segregationist senators from Mississippi during most of the period between Brown and the 1970s. Worse yet, you could imagine the possibility that Virginia would actually have a James Eastland Professor of Law. Now, James Eastland was the worst white supremacist serving in the United States Senate. He was the one who went around the South giving speeches, inciting people to violence in response to Brown, but fortunately he did not have a chair named after him. Worse yet, you could actually imagine being the James McReynolds Professor of Law. Now, my students in the room know all about James McReynolds. James McReynolds, for those of you who are not familiar, was the worst human being ever to sit on the United States Supreme Court. He was a bitter anti-Semite. He was a terrible racist. He was such an SOB that Woodrow Wilson promoted him from Attorney General because he was desperate to get him out of his cabinet meetings. He was also the only UVA grad ever to sit on the United States Supreme Court. It's a miracle that he doesn't actually have a professorship named after him. When I left Virginia, I remember telling my students the last day of class, which was almost exactly 2 years ago, that I was leaving Charlottesville and UVA with much reluctance, but I was hoping one day that I would become the Boston Red Sox Professor of Law or the Fenway Park Professor of Law. Those chairs don't exist yet to my knowledge. Martha, Seth is here today. I think this might be a fruitful topic for you to explore after I'm done talking. Seth, I hope if you're willing to donate such a chair that you might qualify it so that the first occupant is your flesh and blood. I think that would be a reasonable restriction. Until that day arrives, I am absolutely delighted and thrilled to be the Kirkland and Ellis Professor of Law. I apologize. Now I've wasted 10 minutes of your time talking not only about real chairs, but imaginary chairs as well. I'm going to spend the rest of the time talking about racial equality in American history. Now, it is customary on these occasions actually to talk not about what you were working on, but what you're working on now. What I'm working on now, as I'm afraid all of you are aware, you've heard me talk about it at length, I'm working on a project involving the backlash effect of prominent court decisions. But I suspect that my colleagues and my students are sick to death of hearing me talk about this. My doctors tell me I have backlash on the brain. I'm sure many of you would share that diagnosis. So I'm going to give a different talk. I actually would have most liked to give yet another talk, which is a talk about baseball and race. That's a book that I'm hoping to write next, but I haven't really worked that one out yet. It's just an aspiration. Maybe by the time there's a Red Sox Professorship of Law, I'll actually have that book further along, and I can talk to you about that. Instead, I'm going to talk to you about racial equality in American history, which is the subject of my last book. I don't think I've ever talked about that in Cambridge before, so hopefully this is fresh material for most of you. So I'm going to spend about 30 minutes talking about something other than chairs and hopefully something other than baseball, and then we'll have a little bit of time for questions. So I'm going to offer several discrete observations about racial practices and attitudes in American history and how and why they change over time. I have 8 discrete points. My students in the room know I have a fetish for lists, just like I have a fetish for the Red Sox. We might have called this talk instead 8 things that Mike Klarman learned or thinks that he learned about racial equality in American history while working on his last book. I'm going to make 8 points, and for each one, I'm going to give you a concrete illustration or two. So first point, racial progress in American history has not been inevitable. There is a standard narrative, I believe, which is that we have a story of constant progress. We started with slavery. The Revolutionary War put slavery on the road to extinction in the North. It weakened slavery, but not fundamentally in the South. The Civil War then ended slavery in the South. Slavery was then replaced by a regime of white supremacy. That regime was gradually weakened over the course of the 20th century, and then as a combination, perhaps, of Brown versus Board of Education and the direct action of the civil rights movement, direct action phase of the civil rights movement, Jim Crow was finally eliminated. I think that narrative is deeply misleading. we have had periods of racial regression as well as racial progress, and I'll just give you two quick examples of eras when racial attitudes and practices clearly worsened. African Americans in the antebellum South clearly lost legal rights over time. There were states that allowed African Americans to vote in 1800, which took away their right to vote during the Jacksonian period. There are states in the Northwest, specifically Indiana, Illinois, Iowa, which actually adopted constitutional provisions barring African American migration in the 1850s. It's pretty clear that African Americans, at least in terms of their legal rights, were better off in 1800 in the North than they were in 1860. Okay, second example, which is probably more familiar to many of you. During Reconstruction, Southern blacks could vote, they could hold office, they could serve on juries. Several Southern states actually passed laws forbidding race discrimination in public accommodations. That changed pretty dramatically 30 years later. By 1900 or so, Southern blacks were almost universally disenfranchised. They were universally excluded from juries. The last blacks were eliminated from public office holding. The number of blacks being lynched annually increased in the 1890s to the point where it was over 100 a year. Southern blacks were almost surely worse off in 1900 than they were in 1870. So there's nothing ineluctable or inevitable about racial progress in American history. It is a story of fits and starts, progress, and regression. Second point, racial progress has not been primarily a result of whites simply seeing the light and doing the right thing. The conventional view, which I think is again illustrated perhaps best by Gunnar Myrdal, who wrote a famous book during World War II called An American Dilemma, according to this conventional view, there is this American creed of universal equality stated in the Declaration of Independence. And mostly what has happened over the course of American history is that we have gradually adjusted our practices in the direction of realizing these ideals that are stated in the Declaration of Independence. That we came to realize that white supremacy was somehow inconsistent with this idea of universal equality, inconsistent with the American creed. I think that account is also deeply misleading. First of all, African Americans have had to fight for all the change that has been accomplished. And second of all, conditions have had to be ripe on the ground. That is, material conditions have had to be ripe for change to take place. So those are actually my second and third points. The point about African Americans having to fight for change, and third, the point about the opportunity structure having to be there, conditions having to be ripe. So with regard to blacks fighting for their rights, I'll give you a couple quick examples. It was slaves running away from their masters during the antebellum period, which led Southern whites to demand a more draconian fugitive slave law, which Congress gave them in 1850, which in turn led to the alienation of Northerners and increased abolitionist sentiment in the North. Second example, President Roosevelt in 1941 issued a famous executive order barring race discrimination in defense contracting. He did that not simply because he saw the light and it was the right thing to do. It had obviously been the right thing to do for the last previous decades, if not centuries. He did it because A. Philip Randolph, the leading African-American labor leader in the country, was threatening to march 100,000 African Americans into Washington, D.C., and the last thing the administration wanted, with the country at the precipice of war, was to have angry blacks protesting job discrimination in war contracting. Last example, Harry Truman in 1948 issued his famous executive orders desegregating the military and the federal civil service. He did that not primarily because it was the right thing to do. He did it primarily, not exclusively, because of black political power. His advisors told him explicitly if he wanted to have a prayer of winning the presidential election in 1948, he needed to win a large share of the black vote. And one way to do that was to demonstrate his commitment to civil rights by desegregating the military and the federal civil service. And in fact, that advice turned out to be true. Truman was elected president only because he won 2/3 of the black vote. If he had won 1/3, he would not have won the election. Okay, the third point that I've already mentioned, African Americans demanding their rights has never been sufficient. It's also necessary for conditions to be ripe. Now, there are a lot of deep-seated forces that I think were essential to African Americans making strides toward greater racial equality. I'll mention a couple of these. These are long-term, deep-seated forces. One has to do with growing education. After the Civil War, most African Americans were illiterate because it was a crime under slavery to teach them to read and write. It is very difficult, of course, to organize a social protest movement among people who are illiterate. As blacks made educational gains over the decades, it became much more difficult to justify disenfranchising them. It became much more difficult to justify excluding them from advanced education. And it became much easier to organize a group that had basic literacy skills. In addition, people who are educated have a much easier time imagining a different world, a much easier time imagining a different set of social relations, whereas people who are less educated tend to regard what exists as somehow inevitable. Another important factor in the long term was the Great Migration, what historians call the Great Migration to the North. Between 1915 and 1960, about 5 million African Americans moved largely from the rural South to the urban North. They did that largely because they had job opportunities available to them which had never been available to them before, but some of the consequences of that were an immediate increase in political power. In the rural South, blacks were almost universally disenfranchised. In the urban North, in places like Chicago, Philadelphia, New York, they not only voted, but they largely voted without restriction, and they often held the balance of power between two roughly equally balanced political parties. Blacks have been drawn by better jobs translated into economic power. Economic power can be leveraged into social change. Think Montgomery bus boycott, that's using your economic clout to try to leverage social change. There were better schools in the North, so African Americans got a better education. There were different racial mores in the North, looser racial mores. It was possible in the North to have an aggressive militant black newspaper like the Chicago Defender or an aggressive organization like the NAACP. In the 1910s, you could not have established such an organization in most of the South. You could not have had such a newspaper in much of the South. I really want to emphasize this point. It's almost impossible to reform a nearly totalitarian system like white supremacy entirely from within. The system is self-sustaining. African Americans can't vote, so they can't change the system through politics. African Americans are mostly tenant farmers and sharecroppers, so they can't acquire economic clout, which could be used to leverage social change. Blacks are not allowed to become very well educated, so they can't become lawyers and litigate against the system. And finally, and perhaps most importantly, African Americans in the South did not have protection from physical violence, and it is very difficult to challenge the status quo when doing so may get you beaten up or worse. External pressure is required to change such a system. That means having African Americans outside of the South who can use their political influence, who can use their economic clout to try to influence the national government, try to set up organizations like the NAACP, which is mostly a northern organization in its early years committed to changing race relations in the South. I think that's how to understand the drive for anti-lynching legislation in the 1920s. It's mostly white congressmen from northern cities with large black constituencies trying to use the power of the national government on behalf of Southern black brethren who are still at risk of being lynched. That's also, I think, the right way to understand the NAACP in the 1910s or 1920s, mostly a northern organization which is trying to use its legal clout on behalf of Southern blacks. Third long-term factor, I already mentioned education and the Great Migration. Urbanization was also critically important. African Americans moved within the South just as they moved from the South to the North. Indeed, many more African Americans were moving from southern rural areas, southern farms, to cities. In the cities, you have better schools, better education. Often black schools in the cities are better funded than white schools in the rural countryside. You have better economic opportunities. In cities with a large black community, you can take advantage of segregation to create a black middle class of entrepreneurs and professionals. Black doctors, dentists, undertakers, teachers, and preachers, they take advantage of the segregated economy and a black clientele to achieve middle class status, and then they can use some of their economic clout to leverage it for social change. There's better physical security in cities. Lynching was always primarily a rural phenomenon, not exclusively, but primarily a rural phenomenon. And again, it is hard to demand your legal rights when doing so may get you beaten up or killed. In addition, of course, in cities, it's easier to overcome standard collective action problems. In organizing a social protest movement, you got to organize people, and it's easier to do that in cities with better transportation, better communication. People go to the same churches and so forth. It's much easier to organize. Now, there are also important short-term factors, and I'm mainly going to emphasize, and I think it's a little bit ironic or even perverse, but war in American history has been very conducive of progressive racial change. The Revolutionary War, as I've already alluded to, killed off slavery in the North, and for a brief period of time, it put slavery on the defensive in the South. The Civil War, of course, ended slavery and resulted in post-war constitutional amendments that secured greater racial equality, both civil rights and political rights for African Americans. World War II was a watershed in the history of racial equality in the 20th century. The ideology of the war, the role played by 1 million African American soldiers fighting for democracy, the continued migration of over 1 million blacks from the South to the North in the 1940s, with the increase in political power that resulted in, and in addition that produced, and finally the so-called Cold War imperative for racial change that followed the war. That's the Soviet Union and the United States competing for the allegiance of non-white third world countries, with American system of Jim Crow being an albatross around the nation's neck, because how do you convince the non-white third world that they ought to support democratic capitalism when the Soviets are saying, well, it's tantamount to white supremacy? Those factors together produce dramatic changes in racial attitudes and practices. It's not an accident that in 1947, Major League Baseball was desegregated by Jackie Robinson. In 1948, as I've already mentioned, Harry Truman desegregated the military and the federal service. Felix Frankfurter hired the Supreme Court's first black law clerk, a Harvard Law School graduate, William Coleman, in 1948. First black general in American history was promoted during World War II. A black man won the Nobel Peace Prize in 1950. All of this is a function of changes that were set in motion or accelerated by World War II. Even in the South, dramatic changes are afoot as a result of these kinds of forces that are reaching their peak after and during World War II. So black voter registration increases fourfold in the decade of the 1940s in the South. Southern juries are beginning to desegregate, even in small cities in Mississippi. Minor league baseball teams, even in places like Birmingham and Montgomery, Alabama, are hiring their first black ball players in the early 1950s. Everything is ultimately about baseball, as those of you who are connoisseurs understand. All right, so those are short-term factors. Moving on, fourth point. Racial progress has often been an unintended consequence of actions that were undertaken for other reasons. Now, as many of you are aware, the North initially, this is speaking in general terms, the North initially fought the Civil War not to end slavery, but rather to put the Union back together. Republicans were prepared to commit to a constitutional amendment that would have forever protected slavery against congressional interference. That's the so-called Corwin Amendment. It passed both houses of Congress by 2/3 majorities. Lincoln was happy to sign off on it. That was the Republican Party's platform. The national government does not have the authority to interfere with slavery in existing states. Congress repeatedly resolved a statement of the war aims during the first year of the war, and those statements made clear that the purpose of the war was not to suppress the institution of slavery, but rather to put the Union back together. What changed, of course, is that the war did not go well. By the summer of 1862, Lincoln was desperate to do something that would help the Union in its war effort. He realized that if you emancipated the slaves, not only were you subtracting a third of the Confederate labor force, and of course it was slaves that were still growing the cotton that was financing the Confederacy, not only could you subtract those slaves from the Confederate labor force, but if you were daring enough, you could enlist them in the Union military, so they would not just be a subtraction from the South, but an addition to the North, and ultimately, of course, 200,000 African Americans fought wearing the Union blue. It is important to emphasize, however, that emancipation was incredibly controversial. Lincoln's Emancipation Proclamation led to riots in northern cities, most famously the New York Draft Riot in the summer of 1863. It cost the Republican Party dozens of seats in the 1862 congressional elections. The abolition of slavery and the development, the advance of black civil and political rights that came after the war, those were unintended consequences of a war that was fought for other reasons. All right, I think I'll limit myself to one example there just to save a little time. Moving on to the fifth point, whites have often had ulterior motives for the racially progressive positions that they have been willing to take. Couple examples. The framers of the Constitution authorized Congress to abolish the foreign slave trade in another 20 years. They did that not because they were opposed to slavery. They did that because Maryland and Virginia already had a surplus of slaves, and they wanted to be able to sell them south to Georgia and South Carolina without having to compete against a continued supply of slaves from Africa. Northern free soilers, that is, those Northerners who wanted to keep slavery out of the Western territories, their principal motivation was not concern about the welfare of Southern slaves. Their principal motivation was white supremacy. They wanted to preserve the Western territories for white people. Yet ultimately, this struggle to keep slavery out of the Western territories is what created the Republican Party, and the election of a Republican president in 1860 is what led to the secession of the South. Last example I've already alluded to, after World War II, the Cold War imperative was an important force for progressive racial change. The State Department, which was not traditionally known as a bastion of racial progressivism, the State Department was quoted in the Justice Department's brief in Brown, arguing to the justices, as a matter of national security, you need to abolish Jim Crow because racial discrimination is grist for the Soviet propaganda mills. Right? That is the State Department, the Truman administration, taking a progressive position on race, not because it was the right thing to do, but because they understood that for national security reasons, you needed to support racial equality. Moving on, point number 6, there is an important, but I think not widely appreciated dynamic by which racial change has frequently occurred in the United States. The North and the South start out having slightly different racial regimes, but not dramatically different, not the difference between night and day. So, northern states after the Revolutionary War put slavery on the road to extinction. In the South, slavery is temporarily on the defensive, but it makes a fairly quick and successful comeback. The North is no racial paradise. Northern blacks don't have access to decent jobs, they're disfranchised, they're excluded from public education, there are race riots in which they're killed. The North is no racial paradise, but it doesn't have slavery, unlike the South. Southerners over time become concerned that their racial regime is going to be threatened by the intervention of the North and the national government. So, for example, slave escapes that are facilitated by Northern abolitionists lead Southern whites to demand a more draconian fugitive slave clause from Congress, which they get in 1850. Similarly, Southerners, because they are on the defensive with Northerners trying to keep slavery out of the territories acquired from Mexico in the War of 1846 to 48, now they come back and Southerners demand access to Western territories that previously were off limits to slavery, like the Kansas and Nebraska territory. with Southerners demanding access to federal territories from which slavery had been excluded, Northerners now become more resistant. So Northerners are repulsed by the Fugitive Slave Act of 1850, these common scenes in northern cities, especially Boston, of shackled, terrified slaves being dragged back into slavery with the assistance of federal troops. These have the effect of repulsing Northern opinion. Efforts by Southerners to readmit slavery to Kansas and Nebraska, where previously Northerners had been secure in the conviction that it was forbidden, lead Northerners to form the Republican Party in 1854. The Republican Party is created in response to the Kansas-Nebraska Act. Now, Northern politicians quickly discover that they can win votes in the North by scaring Northern voters into believing that there is a Southern slave power out there that is determined to interfere with their liberties. Most Northerners care much less about the welfare of Southern slaves than they care about slavery impinging on their own liberties. For example, requiring them to be conscripted into posses to assist in the rendition of fugitive slaves, or requiring them to compete with slave labor in the territories where they would rather enjoy unmitigated white supremacy. Northerners then become more resistant to compromising with the South. Southerners, in turn, become even more defensive, even more paranoid. By 1860, they are demanding that Congress pass a slave code for the territories. Northerners are even more repulsed. They elect a Republican president. That leads the South to secede with this alien entity, Abraham Lincoln, who's not even on the ballot in Southern states, now the President of the United States. He's the one appointing judges. He's the one appointing customs officials and postmasters. The Southerners are scared to death, and they secede from the Union. Same dynamic operates 100 years later to produce landmark civil rights legislation. Again, the South has a formal system of white supremacy. The North does not, but again, the North is no racial paradise. African Americans are not allowed to move into white neighborhoods. They are deliberately segregated in schools, not by state law, but by gerrymandered attendance zones, by various other school board schemes that ensure that the schools are segregated. Blacks are denied access to the best jobs in the North. Southerners become increasingly concerned, defensive, and paranoid after World War II that the North is going to intervene to suppress Southern racial practices as they've traditionally existed. Brown makes that threat very concrete, and the response of white Southerners is to mobilize extraordinary resistance. So Southern politics becomes more extreme. Politicians compete against each other to occupy the most segregationist point on the political spectrum. Politicians actually give incendiary speeches which all but openly solicit violence. And when that violence arrives on the streets of Birmingham and Selma in 1963 and 1965 and is televised to a national audience, it leads Northerners to respond with outraged demands that civil rights legislation be passed in order to suppress the practices of Bull Connor and Jim Clark and so forth. So the dynamic, again, just to restate it quickly, is initial differences in racial regimes, which are fairly slight, leads white Southerners to become more defensive, more paranoid, to demand greater protection from the national government, which in turn repulses Northerners who now become more insistent on doing something to interfere with the South's racial regime, and you get a kind of ratcheting up with this dynamic, and it ends up being, ironically, white Southerners fighting as hard as they can to preserve slavery and then 100 years white supremacy, who end up accelerating its demise. Okay, so the next 2 points, the last 2 points, have to do with the Supreme Court. I've already alluded to many changes that were taking place in the late 40s, early 50s in Southern racial practices and attitudes. Notice these are all taking place before Brown versus Board of Education is decided. The last 2 points, points 7 and 8, are, first of all, the court has not reliably been on the right side of history with regard to race, that is, on the racially progressive side. And finally, whether the court's been on the right side or the wrong side, the court has generally been reflecting the racial views of the country much more than it has been shaping them. So, point 7, historically the court has opposed the interests of racial minorities at least as much as the court has sided with those interests. Before the Civil War, the court reliably sided with slave owners. The court upheld the fugitive slave laws of 1793 and 1850, and the court struck down northern state efforts to protect free black citizens in the North from kidnapping. In the infamous Dred Scott decision in 1857, the court not only said it was unconstitutional for Congress to interfere with slavery in federal territories, the court also said that the Constitution did not protect even free blacks in their constitutional rights, that whites owed no respect to the rights of African Americans, even if free. After the Civil War, the Supreme Court struck down on what I think we would regard today as legal technicalities, civil rights legislation, and the court invalidated the convictions of perpetrators of racial massacres. People who had lynched, whites who had lynched African Americans were released on legal technicalities. In the early 20th century, the court rejected challenges to racial segregation. The court rejected several challenges to Southern state schemes for disenfranchising African Americans. Over the last 4 decades, since the end of the Warren Court in 1969, more often than not, the Supreme Court has struck down race-based affirmative action, and the court has struck down efforts to promote minority racial districts, which would enhance the ability of racial minorities to elect representatives of their choice. Just a couple of years ago, the Roberts Court ruled that even the voluntary use of racial criteria in order to promote racial integration in public schools violated the 14th Amendment, which I believe most constitutional historians regard as an extraordinary perversion of the original understanding of the 14th Amendment. It's really only in the half century between World War I and the end of the 1960s that the court reliably sided with the interest of African Americans pursuing civil rights. But all of those rulings pretty much reflected national public opinion. Let me give you a couple quick examples. In the 1930s, the court twice intervened to overturn the convictions of the Scottsboro Boys. The Scottsboro Boys were 9 African-American teenagers who were falsely accused of raping 2 white women on a freight train in northern Alabama in the spring of 1931. Their trials were legal lynchings. That is, there was a mob surrounding the courthouse. They had no legal representation to speak of. There were no blacks allowed to sit on juries. Their lawyers were intimidated out of making arguments for fear that those arguments would end up getting their clients lynched if by any chance they were successful. National opinion was appalled by Alabama's efforts to execute 8 black teenagers who likely, based on the evidence that was known at the time, who likely were innocent of the crime charged. With the aid of hindsight, they were not likely innocent, they were clearly innocent. There's no doubt when the court intervened that most of the country supported the court's decision. In 1944, the court struck down the white primary. That is the primary mechanism used to disenfranchise blacks by not allowing them to participate in the only elections that mattered in the 1940s in the one-party South. At that time, opinion polls showed that 70% of the country supported the idea that the federal government should intervene against Southern electoral devices that were used to disenfranchise blacks. Finally, and perhaps surprisingly to many people, Brown versus Board of Education was supported by a majority of the country from the day it was decided, according to Gallup polls that were taken in the summer of 1954. So even when the court has favored the interests of racial minorities, it's usually been reflecting rather than resisting dominant public opinion. Now, to be fair, we should also note that the court's less attractive race decisions also generally were reflections of dominant opinion. If I'm not going to give the court a lot of credit for its racially progressive decisions, it's probably only fair not to give the court that much blame for its racially regressive decisions. When the court in 1857 said African Americans have no rights that white people are bound to respect, it was almost surely reflecting dominant opinion in the country. Blacks in 1857 could vote only in 5 New England states, which together had only 6% of the North's black population, and only 10% of the nation's black population lived in the North. So you're talking about blacks being able to vote in 6% of 10% of the country. Blacks were excluded from public education or else segregated in every state except Massachusetts in 1857. And as I've already mentioned, blacks were literally barred from migrating to several northern states. It's almost surely the case that that aspect of the Dred Scott decision, saying free blacks have no constitutional rights, would have won overwhelming support in a national referendum in 1857. When the court in 1896 ruled that racial segregation of railroads was permitted under the Constitution, again, the justices were almost surely reflecting dominant opinion in the nation. Even the Republican Party, the party of Lincoln and the party of Emancipation, had by the 1890s largely abandoned the interests of racial minorities. That's why the Plessy decision was greeted with a yawn of indifference from most of the nation's major newspapers. The New York Times noted the decision in a page 3 item on railroad news. The decision was barely noticed, much less criticized, except in black newspapers. Finally, it's worth noting that when the court in 2007, in Parents Involved, invalidated student allocation policies which took account of race with the motive of promoting integration, most school districts in the country had already abandoned efforts at promoting integration. At most, something like 5 to 10% of the school districts in the country still were employing voluntary integration policies. Essentially, the court was invalidating voluntary efforts to promote racial integration at a time that most of the nation had already given up on the idea that government should be pursuing that goal. So the bottom line, at least on this last point, is the Supreme Court mirrors American society at least as much as it shapes it. The justices could not have foisted regressive racial rulings on the country had it not been for the fact that the American people were willing to acquiesce in those decisions. If we're not happy with the racial jurisprudence of the court in the last several decades, we should blame ourselves for that at least as much as we should blame the justices. Now, that's an unhappy note, I think, to end on, so I won't end there. I'll simply say I am very optimistic about the Red Sox chances this year. It's all about run prevention. It's a new look, pitching and defense. Certainly, David Ortiz is contributing to that new look in the first 6 games. Thank you very much. I'm honored that so many of you would want to attend my talk, and I'd be happy to take questions if I didn't waste all the time for questions talking about chairs in the beginning of my talk. Thank you very much. Yes, sir.
Thank you very much for your talk, Mr. Klarman, and congratulations on your new chair. I was wondering about your last point. Why would judges, since it protects from politics, care what American people think? I understand the national security interest in Brown v. Gore, but before and after,
Right.
judges care.
Right. So justices on the Supreme Court are more insulated from politics than most politicians. They have lifetime tenure. They don't have to worry about their salaries being reduced. They don't have to run for office. That insulates them from temporary fits and starts in public opinion. It doesn't insulate them from the basic fact that they are living in the same time and place and the same culture as the rest of us, and they tend largely to reflect that culture. So there are lots of illustrations of this, but the court decided Brown in 1954. The justices would not have dreamed of deciding the case that way 20 years earlier. The Supreme Court protected the right to abortion and women's equality rights under the Equal Protection Clause after the women's movement, not before. It was not conceivable that a court would protect the right to same-sex marriage until the last 10 or 15 years. That's because the court is never at the vanguard of social change. It's true the justices have a limited amount of flexibility to contravene public opinion, but the fact of the matter is, first of all, they're not that likely to have the inclination to do things that are dramatically out of touch with popular opinion, because they are part of public opinion. And second of all, even though they're insulated, they're not immune. If the justices were to do something that struck most of society as simply unacceptable at the time, you can impeach justices, you can pack the court, you can pass constitutional amendments, you can make their lives miserable. My federal courts professor used to talk about how Congress could always, in theory, move the Supreme Court to the bottom of the Potomac by statute if they wanted to do that. There's nothing in the Constitution saying you can't. So you're right that the court probably has a little bit greater insulation from politics than politicians. That's why they strike down flag-burning prohibitions. That's why they strike down school prayer. But even on those decisions, they're backed up by a good 30 to 40% of the population. If you're talking about them deciding Brown 20 years earlier, there would be so little support that they just wouldn't do it. And the best evidence for that is the NAACP wouldn't bring the case because the NAACP only brought cases they thought they could win, and they knew they couldn't get the court to strike down segregation until after World War II. But it's a very good question. Ian. Yeah.
Wonderful. Any thoughts on the trajectory of race relations over the next 5 or 10 years?
If I say no, can I duck? I mean, this is an incredibly hard question, right? I mean, the trick is sort of trying to figure out exactly where we are. The change is extraordinary. I think people who are as young as most of you in this room can't really appreciate how extraordinary the change is. 50 years ago, the idea that you could have had a black president, that the last 2 secretaries of state before Hillary Clinton would have been black, or that you could have had a female secretary of state. In the 1950s, the idea that you had a black justice on the Supreme Court, those were all things that I think were largely unfathomable. That's an incredible change. On the other hand, I think people like Martin Luther King, if they looked at New Orleans after Hurricane Katrina, would be appalled at how little progress we had made on the plight of poor urban African Americans, the situation, the violent situation, the lack of education, the fact that young African Americans are more likely to end up in jail than going to college. They would be appalled by that. They would have expected that we would have worked out these things so that someone's life chances didn't depend on their race at birth. So it's a very complicated picture trying to put these things together. You know, in one way, I think Obama's election is incredibly inspiring, and I think the role modeling effect, the fact that you can actually tell people you really could be president of the United States. You can say that to black kids, and they don't say, "What, are you crazy?" They can look and see. That's incredibly important. On the other hand, lots of people's reactions to Obama's election is, well, now we certainly should forbid affirmative action, right? I mean, Obama can become president. We don't need to worry anymore about race. Race is not a concern. If you can't succeed in today's world, it's your own fault. Right? I don't regard that as a particularly constructive approach, but I think that's one way in which people use Obama's election on race. So I'm not very good at predicting the future. My students know that they can make a fortune betting against my predictions on the Supreme Court and on baseball usually as well, but I don't know. I mean, I like to be optimistic. I like to think that things are improving. I don't see a major social movement of reform that's going to address the problems that are so severe. I'm a little pessimistic about that, but I try to tell myself you need to be optimistic because pessimism doesn't do any good. Right, Lisa? I learned that lesson from my spouse. Got to be optimistic. Got to be thinking positive thoughts. Yeah, Aaron.
So this follows nice on Ian's question, because as you were speaking, which was so interesting, I kept thinking of the metaphor that's often used of slavery as a disease or race as a
Right.
forward-moving line.
Right. So the lesson is I should never call on my colleagues because I'm likely to get these incredibly difficult questions, which there's no way I can possibly answer. That's a great question. I mean, I don't believe in the inevitability of progress. I don't think it's ineluctable. I think a lot of feminists in the 1970s would say that there certainly was a kind of regression. If nothing else, the fact that the ERA looked as if it was destined inevitably to pass in 1971-72, the ERA ends up getting shot down. You know, there are various ways in which you might be able to trace a regression. On the other hand, Hillary Clinton was almost elected president, and I think that's probably something that in 1970 it would have been hard to predict. With race, you know, I don't think it's inevitable that we will progress, but it does seem really hard to imagine a movement back to slavery, a movement back to formalized segregation. My concern is that I don't see that much impetus to solve this problem of urban poverty, which is not unrelated to race. I don't see us moving forward on that, and I think you could argue that we've regressed there. We've clearly regressed on school desegregation. There is more school segregation in the North today than there was in 1954, and there's more school segregation in the South than there was in 1980. So we clearly have regressed, and there doesn't seem to be much interest. We actually have a majority on the Supreme Court who doesn't seem terribly concerned about the fact that we have school segregation, and indeed, perversely, they're prepared to say it's unconstitutional to voluntarily try to integrate, that violates the 14th Amendment. So that seems like a regression to me, but I do have a hard time seeing a complete regression back to slavery, formal Jim Crow, and so forth. On the disease point, you know, it is a disease, but it's also, you know, whites had very concrete material interests in preserving segregation. It wasn't just a disease of the mind, it was an entrenched bias in favor of preserving the status quo. If nothing else, you excluded black people for competing for the same jobs. You excluded black people from other positions of power and privilege, and that had concrete benefits. So it's not just the disease. Once you have a certain status quo, people have very deep entrenched interest in preserving it. I think what's happened in the last 40 years is we substituted the formal racial system for a series of formally race-neutral policies that have the effect of entrenching the racial subordination. And through a system of rules like Washington versus Davis, the idea of a colorblind constitution in the affirmative action cases, we've kind of constitutionally tried to cement that into place. But again, I don't lay all the blame or most of the blame on the Supreme Court. I don't think the Supreme Court could get away with those decisions if much of the country didn't support them. Yeah. Stan.
Thanks again for the talk.
Sure.
I'm curious about what happens when you expand the dynamic beyond blacks and whites and into the realms of other minorities. Some of the issues today include immigration with mainly Latinos, social security, racial profiling with Arab Americans. How do the dynamics that you point out, are they portable over to these other issues, or are there
Right.
some dynamics at play amongst minorities themselves?
Right, so that's another great question, and it gets me back to Ian's question about projecting into the future. So, you know, people are aware that by 2050, the country will be majority-minority. It's already the case that births are close to being majority-minority. The country's going to look totally different. It may become nonsensical to talk about somebody being African-American because there's going to be sufficient race mixing. However, having said that, it's still the case if you look at the indicia that social scientists emphasize to look at racial assimilation, and the two indicia that are most prominent tend to be racial intermarriage and residential segregation. It is the case that African Americans are dramatically less assimilated than Latinos or Asians. So you get the same lesson. I spent a fair amount of time, much too much time, reading the marriage section of the New York Times on Sunday. Some of you may look at the weddings announcements. If you look at that, right, that's real social science. Read the weddings announcements in the New York Times. Look at the number of racial intermarriages between whites and Asians and compare it to racial intermarriages between whites and blacks. The intermarriage rate, I believe, for African American females is 6%. For Asian females, it's 50%. And as you've pointed out to me, it's very complicated talking about Asians because there's a big difference between East Asians on the one hand and South Asians and so forth. And this plays into affirmative action these days, right? There are these stories in the Boston Globe and the New York Times. Who really is burdened by affirmative action these days? There's a decent argument that it's Asians. Asians with the same board scores are not getting into Harvard as whites with, you have to have 50 points higher as an Asian as opposed to a white person. So these are very complicated questions about the relationships. I tend to talk about black and white because for most of American history, that's largely what it was. But in the last 40 years, it's much more complicated, and it's becoming much more complicated. And it could be that the race problems, in a sense, wither away as it becomes hard to talk meaningfully about somebody's race because there's so much interracial marriage and mixing. You certainly see that in the younger generation, that race is just a less significant category than it is for people my age or older. Yeah, Dean Minow.
It's a fabulous talk, and as is often the case in your work, we really start to see what political economy means, what it means to think about interests and politics. But there are pieces of your story that also involve individuals and culture. And so I wonder if you could just reflect, looking at the suite of this, particularly with regard to the causes and effects of legal change, the role of individuals and the role of culture.
Right. Yeah, so I often get asked that question. And when you get into these deep-seated forces, it sounds like you're pretty much a materialist, a determinist, and that makes it sound that individual agency isn't very important. Sometimes I think that's true, sometimes it's not. I think it probably mattered tremendously to the history of racial change in the United States that there was a person like Martin Luther King who happened, and it's just an accident. I mean, King was selected to head the Montgomery Improvement Association because he happened to be a newcomer to Montgomery, and therefore he didn't have this long history of feuds that most of the black ministers who were older had. It's just an accident that he happened to get picked as a 26-year-old newcomer to Montgomery to head the Montgomery Improvement Association and then become the head of the Southern Christian Leadership Conference and the most important race leader in the 1960s. I think it probably mattered a lot to history that Martin Luther King was there when he was there. I don't think it mattered a lot to history that Thurgood Marshall was there to argue Brown versus Board of Education in 1952 and 1953. I do think it mattered a lot that there was someone like Thurgood Marshall who was heading the NAACP, going through the South, organizing African Americans, giving people hope that it was possible to change the world. I think people forget that lawyers might play a really important role other than arguing cases in court. I think the Supreme Court was going to decide Brown the way they did, regardless of who argued the case, but I don't think it was inevitable that the NAACP would have this incredibly charismatic, talented, he referred to himself, or Charles Hamilton Houston, his predecessor, referred to themselves as evangelists and stump speakers. They went around to local black communities in the South, convincing them that it was possible to change the world, that you should have hope for a better future. They role modeled the fact that you could have African Americans who accomplished great things in the law. And I think those were incredibly important, and in some ways just as important, if not more important, than the arguments they made in court. So, yeah, sometimes it matters, individuals matter, sometimes less so. If you think Supreme Court decisions matter a lot, every one of the race decisions that I would refer to is a 5-4 decision in the last 30 years, which means everything turns on either Justice O'Connor or Justice Kennedy, meaning individuals matter a lot, if you think the Supreme Court decisions are hugely influential. I'm kind of torn on that. You know, I think they largely reflect the existing social and political mores, so they probably matter at the margins, and they matter in unpredictable ways because sometimes they produce backlashes and so forth. But yes, individuals matter, and collectively the efforts of lots of individuals fighting for change, without that you would never get social reform movements. Yes, sir?
I took a Andrew Napolitano's book, Red Scott's Revenge, the last chapter about baseball. My question.
Roger Toney was a Yankees fan. I don't know if everybody knows that, but...
My question is about a case called Northwest Boston, which was a challenge to the Voting Rights Act.
Right.
It was decided on very stretching
Right.
that element or another one. And does the Congress have a role here in revisiting that act so that it can pass constitutionally?
Right. So there are 5 justices who almost surely think that that provision in the Voting Rights Act is unconstitutional. And as you say, they decided to basically interpret the statute to avoid the problem. But it's pretty clear there were 5 who were inclined to strike it down. The Voting Rights Act is in some ways one of the most efficacious laws in the history of the United States. Black voter registration in Mississippi went from 6% the year before the law was passed to 60% within a couple of years. An incredibly effective statute. When the statute was amended in such a way as to enhance representation of, or to enhance the ability of minority voters to elect representatives of their choice, that had a profound effect. The Black Congressional Caucus increased by 50% in the 1990s. But it's complicated, right? I mean, the Supreme Court started saying right after that happened that maybe it's unconstitutional to promote these minority districts. And a lot of political scientists think that promoting these minority districts helped elect a lot of African Americans and Latinos, but also dramatically helped elect more Southern Republicans. So, it's not obvious that striking this down would be that much of a blow. It might mean fewer minority representatives, but it might also mean less political support for the Republican Party, which fewer than 10% of African Americans vote for in every election since 1964. So even there, I think it's a little bit complicated. But it does seem extraordinary that a court that is composed of self-professed minimalists, people who are restrained, people who want to defer to local governments, people who want to defer to legislatures, that they're now striking down affirmative action. They're striking down school board efforts to promote integration. What could you prefer better than in local democracy than a local school board voluntarily deciding to integrate its schools? It just seems extraordinarily activist and a little bit hypocritical to me, given that you can't really justify these decisions based on the original understanding of the 14th Amendment. The colorblindness interpretation of the 14th Amendment simply can't be defended as a matter of history. And the justices don't try to defend it that way. They just say colorblindness is what we read off the text of the amendment. Well, for 80 years, most Americans didn't think that was the obvious meaning of the text. So how is it that Justice Scalia knows that the text commands government colorblindness? So I find it very disconcerting that the court is so aggressively challenging progressive racial measures on what I think is a very thin constitutional basis.
So we have 2 important things left to do. First, right here. There's an actual chair. Good there. The other important thing we have to do is to toast you, and we have a reception right here, and please, everybody join us.
Thank you all for coming.